Hello, and welcome to the National Museum of the American Indians 2021 Summer Virtual Teacher Institute, The Power, Authority, and Governance of Native Nations, Understanding United States Federal Indian Policies. I'm Ed Schupman, Manager of National Education here at the National Museum of the American Indian. I'm also a citizen of the Muskogee Nation, and I would like to say Mado, thank you for joining us for today's webinar. And I hope that you'll be with us for the next 2 days as well. We like to start our programs with land acknowledgements. We gratefully acknowledge the Native peoples on whose ancestral homelands we gather today, wherever we are, as well as the diverse and vibrant Native communities who make their homes here today. For many Indigenous people, belonging is deeply tied to ancestral homelands through relationships with the environment, memories, and cultural experiences lived over millennia. In the United States, people are increasingly doing land acknowledgements, which are meant to recognize that Indigenous peoples are the original stewards of the lands on which we now live and work. These acknowledgements should be motivated by genuine respect for and support of Native peoples. Land acknowledgements are a first step in creating collaborative, accountable, and respectful relationships with Indigenous nations and communities. Many of you already do land acknowledgements for your classrooms. For those who are looking for some guidance, the museum has developed a one-page handout which will be placed in the chat. The National Museum of the American Indian is part of the Smithsonian Institution, a complex of museums, libraries, a zoo, and research centers. NMAI has 2 exhibition locations, one in Washington, D.C. on the National Mall, and the other in New York City in Lower Manhattan. The Cultural Resources Center in Suitland, Maryland, seen on the far right, is where we steward our material collections of cultural and ancestral items, photographs, contemporary art, and paper archives. Central to the museum's mission are strategic partnerships with Native people and our allies. Collaborations with classrooms across the country are important for our continued efforts to share more complete narratives about Native Americans and to advance our goal to foster a more informed understanding of Native peoples. Our newly adopted vision statement works for equity and social justice through education, inspiration, and empowerment. NMAI feels honored to work in education with Native peoples and with committed educators like yourselves. The work of our National Education Initiative, called Native Knowledge 360, is at the heart of our work to make social justice a reality. Native Knowledge 360 has 4 components that comprehensively work together to support the change that we envision for education about Native Americans. The first is a framework for essential understandings about American Indians. I'll tell you more about that in a moment. We're also developing new classroom resources for teachers and students, and you'll have an opportunity to learn more about these during the Institute. We also provide a variety of professional development events for educators in several different formats and settings, such as the Institute you're attending today. And the initiative also includes important partnerships with like-minded organizations. We're posting a link to our Native Knowledge 360 website where you can learn more about the initiative, explore all of our classroom resources, and learn about professional development opportunities. Our framework for essential understandings begins the work of replacing the inaccurate, incomplete, and stereotypic stories about Native Americans that have been so pervasive for centuries. The framework is based on the 10 themes of the National Council for the Social Studies standards, such as cultures, people, places, and environments, science, technology, and society, and our theme for this week, power, authority, and governance. The framework also includes sample key concepts under each of the themes. This document is foundational to our work, and we encourage you to take some time to get familiar with it. We'll be placing a link to it in the chat. During this institute, we'll provide an orientation to United States federal Indian policy by focusing on the impact and consequences of different policy areas on Native people and nations. We'll also spend time discussing why basic knowledge about federal Indian policy can help teachers understand the power, authority, and governance of Native nations. Today, we'll think about why basic knowledge of U.S. federal Indian policy is important, and then preview all of the policy areas that we'll be examining each day. And then we'll hear from our two distinguished speakers who will talk about the colonial and treaty eras, with attention to the legacy of these eras today. I'm sure that many of you recognize Secretary of the Interior Deb Haaland. She's the first Native American to serve as a cabinet secretary in the 244-year history of the United States. Previously, she served a term as one of the first two Native American women elected to the United States Congress. She was elected to serve a second term, but then was nominated by President Biden and confirmed by the Senate to hold the office of Interior Secretary. But Secretary Haaland is many other things. She's a citizen of the Laguna Pueblo of New Mexico and describes herself as a 35th generation New Mexican. The Laguna people have thrived for many centuries on lands that are now part of New Mexico. They were among the first to encounter Spanish conquerors, priests, and colonizers, and to battle against Spanish attempts to wrest away Laguna power, authority, lands, and culture. Haaland is a citizen of the United States, a country that did not confer citizenship to most Native Americans until 1924. Her parents both served in the United States military, as have large numbers of Native Americans in every major U.S. conflict and peacetime since the Revolutionary War. Her mother and other family members attended Native American boarding schools, which were part of an often brutal and destructive education system that was designed to remove traditional culture and languages from the lives of young Native Americans. She's also a citizen of New Mexico, a state that did not legalize voting by Native Americans until 1948. She's a single mother who has personally lived through the challenges of poverty, a condition that disproportionately affects Native Americans. And Haaland now serves as the head of an agency that for much of its history was the source of the oppression of Native peoples. Deb Haaland's own identity and experience has been shaped by this complex history, and she's keenly aware of the many challenges that are faced by Native Americans today. But she's also clearly dedicated to her responsibility to serve all Americans. Her priorities at Interior include tackling issues such as environmental justice, climate change, and family-friendly policies. But she's also focused on the extremely high incidences of missing and murdered Indigenous women and the ongoing trauma and legacy of American Indian boarding schools. When Deb Haaland took office in March this year, it was not only a historic moment, but a symbolic one as well. She's a very accomplished Native American woman and a well-known public figure who has risen to the highest levels of the American political structure. But in many ways, she also typifies the Native American experience in this country. Her story is evidence that there has been some change, and that things are happening that we wouldn't have thought possible a few decades ago. But we still have a long, long way to go and a lot more work to do to bring about social justice for all Native Americans. Our work with you today and over the next 2 days is focused on the power, authority, and governance of Native American nations. This is the 6th of our 10 Native Knowledge 360 Essential Understandings. In the short time that we have with you, we'll focus primarily on one key concept, and that is the impact that colonial and U.S. policies have had on Native American power, authority, and governance. We'll also be talking about the impacts on the lives, cultures, and identities of the people who are citizens of those Native nations. Of course, before there was a United States, before there were European colonies, there were Native nations. Thousands of diverse and sovereign Native nations across the Western Hemisphere, all with their own histories, identities, and cultures, languages, and ways of governing. This is a map that shows indigenous languages and language families at the time of contact. Our native governments were built on cultural values and practices with unique and often democratic principles. Native nations engaged in trade, social relations, diplomacy, alliances, and sometimes wars with each other for thousands of years. This image shows a wampum belt made by the Wendat, or Huron people of the Great Lakes region. Wampum belts were woven with quahog clamshells and were used to symbolically record laws, treaties, or to call people to meetings. The symbolism of this belt indicates that the people of two nations, the Wendat and the Haudenosaunee, walk together in unity. It's said to have been presented by the Wendat to the Haudenosaunee at a treaty in 1612 at the headwaters of the Ottawa River in Canada. When the Europeans arrived, these time-honored ways of life began to experience drastic change. Sovereign and independent Native nations and their leaders had to establish their own new relationships with these often hostile invading nations. But throughout the colonial era, throughout the development and growth of the United States, and to the present day, Native nations have continued to exist in ongoing and evolving relationships with foreign powers. These relationships have gone through many twists and turns over the centuries. The power and authority and governance, as well as the cultures and lives of Native nations and peoples, have often been severely challenged, but at other times empowered during this course of history. Because you're largely an audience of educators, we want to give you some context for thinking about federal Indian policy by first recalling how the eras of American history are typically organized in U.S. history classes. I'm sure this looks familiar to many of you. But as we overlay the federal Indian policy eras, you'll probably begin to recognize how these eras intersect and some of the connections that exist between the U.S. history eras and federal Indian policy eras. You're going to be hearing from expert speakers about each of these policy eras in the Institute. But to start things off, I'd like to take a few minutes to give you a quick overview of each. Native Americans faced many challenges to their power, authority, and governance during the colonial era. Of course, Native nations owned and occupied the lands that colonies wanted, and they were often in conflicts, diplomatic negotiations, or making treaties about lands. There were many other kinds of interactions, but for our purposes of understanding policy and its influence, the colonial governments rightly viewed tribes as nations with their own governments, and they made treaties with individual Native nations. It's important to remember that colonial treaty making set the legal precedent for future relations between Native nations and the United States. This image depicts a meeting that occurred between members of my tribe, the Muskogee Nation, and the trustees of the Georgia colony in 1734. During the treaty era, the United States negotiated and ratified approximately 370 treaties with Native American nations. Many more were negotiated and agreed upon, but never ratified by Congress. While early treaties often focused on land acquisition, they sometimes established trade agreements or military alliances against other European powers. As the U.S. population and power grew, the U.S. government aggressively pursued tribal lands with treaties backed by military campaigns. During this time, many Native nations were forced to relocate to reservations established through treaties. The Navajo Treaty that you see here was made in 1868. This is an image of the original, and it was written on U.S. Army ledger paper and is kept at the National Archives. The United States was very busy during this era, and often tribes were forced to sign multiple treaties, giving up more and more of their lands. The Muskogee Nation, for example, had 18 ratified treaties with the United States. During the Indian removal era, the U.S. wanted the Eastern Indian nations to sign treaties and exchange their lands for lands west of the Mississippi River. The pseudo-justification for removal was that Indians were uncivilized and made little use of their vast lands. But let's be clear, to Americans, Native American lands represented economic opportunity. Removal was further couched in the concept of a manifest destiny to occupy the entire continent from coast to coast. In 1830, Congress passed the Indian Removal Act by a slim margin, giving the president the authority to negotiate Indian removal treaties. Native Americans didn't want to voluntarily give up their homelands. Why would they? And they tried every strategy they could think of to resist removal. After the passage of the Indian Removal Act in 1830 to about 1850, the U.S. government and citizens pressured Native people and used treaties, fraud, intimidation, and violence to remove about 100,000 Native Americans west of the Mississippi. Long-standing relationships took place, and millennia of history were severed, and thousands of Native men, women, and children died on their removals to Indian Territory, the modern-day state of Oklahoma. The map on the left shows the names of the many nations that experienced forced removal to Indian Territory. The map on the right shows the routes taken during the Muskogee removal. Over a period of 10 years, about 23,000 Muskogee people were removed from Georgia and Alabama to Indian Territory. In its next set of policies, the United States turned its attention to the acquisition of Native American lands within the reservations that had been established and to forcing Native people to assimilate mainstream American culture and ways of life. The General Allotment Act of 1887 forced Native nations to allot communal tribal lands into small parcels of acreage for ownership by individual Native people. And then, according to the National Congress of American Indians, what was left, more than 90 million acres, nearly two-thirds of previous reservation land, were taken from tribal nations and given or sold to settlers, most often without compensation to Native nations. This is a historical poster that advertises the upcoming availability of Native lands. The allotment policy was divisive in the Muskogee Nation. One Muskogee group, led by Cheeto Harjo, initiated a rebellion to try and stop the allotment of the Muskogee Reservation. Ultimately, Muskogee lands were allotted and remaining lands were opened for white settlement. Boarding schools across the country were a horrendous failure, inflicting abuse, loss of culture and language, and trauma on generations of young Native American children. The disastrous policy of allotment officially ended under the Indian Reorganization Act of 1934. The Reorganization Act was beneficial in some ways to Native nations. It represented a shift away from the brutal policies of the allotment and assimilation era. Sometimes referred to as the Indian New Deal, the Reorganization Act included efforts to restore Native lands that had been lost, support for the revitalization of Native governments, and programs and projects to stimulate the economies of Native communities. Reorganization was not without its critics in Indian country, who argued that it was not fully planned or implemented, and that it really amounted to yet another way of assimilating Native Americans. Then, with the passage of public law in 1953, the federal Indian policy pendulum swung far to the other side again and sought to terminate federal recognition and assistance to more than 100 Native nations. These policies were economically disastrous for Native tribal nations, and who ultimately lost millions of acres of valuable natural resource lands. In another failed program, the federal policy of the termination era encouraged Native people to relocate from rural reservations to urban areas for, quote, better opportunities. This image is of a poster advertising termination era opportunities in Denver. However, the policy resulted in loss of culture and connection to home communities and created a sense of alienation for Native families. In these urban settings, Native people were exposed to racist views and behaviors, and the good jobs often failed to materialize. With the passage of the Indian Self-Determination and Education Assistance Act of 1975, the U.S. federal policy pendulum swung once again and recognized the power, authority, and governance of Native nations. Native governments were actually proactively involved in the development of the self-determination policies. Since that time, Native nations have been able to exert more control over their destinies, including the self-management of many federal programs that serve Native people. The tribes have also been able to leverage the policies and their own economic gains to become stronger and independent of the federal government. This image is of the mound building, one of the facilities on the Muskogee Nation Tribal Capital Complex in Oklahoma. Next to it is the Muskogee Nation flag, which serves as a symbol of Muskogee Nation sovereignty today. This has been a cursive look at the federal Indian policies you'll be learning more about in this institute. A good general resource to consult for information on relations with the U.S. is Tribal Nations in the United States, an Introduction, published by the National Congress of American Indians. We've posted a link to this guide in chat. Sovereignty means the authority to self-govern. Native nations were sovereign before Europeans arrived. Native sovereignty in the U.S. has been affirmed by hundreds of treaties, various Supreme Court decisions, presidential executive orders, and acts of Congress. We also encourage you to remember that through all of this history, Native Americans have not been mere victims. They have exercised agency, resisted attacks on their sovereignty and well-being, and persisted. Today, sovereign Native nations within the United States still exercise their authority to self-govern. For centuries, Native Americans have been depicted as backward savages. Such beliefs have been perpetuated by people and institutions to justify horrendous treatment and to serve other kinds of political and economic purposes. Native American content in education has been inaccurate and incomplete. Native Americans are, in many ways, an invisible segment of the U.S. population. These omissions and insufficient knowledge perpetuate stereotyped and racist thinking and behaviors toward Native Americans and leave generations of students with an incomplete understanding of U.S. and world history. This has been a profound year of reckoning for a lot of people. There's greatly increased awareness of the effects of systemic racism, and many people are moving beyond awareness to action, to take steps that will counter the effects of invisibility, incomplete narratives, and stereotypical thinking. This is a timely moment for the National Museum of the American Indian as we work to meet our vision of social justice for Native Americans. We'd like all students to learn about Native American perspectives and experiences in U.S. history, alongside those of other historically marginalized citizens. We believe that students should be empowered to recognize information that lacks these perspectives. We want them to think more broadly and inclusively about history. Our work with Native Knowledge 360 is to transform teaching and learning about Native Americans. We're not the encyclopedic warehouse of Native American content, but we are steadily building a library of classroom resources. So far, we're just scratching the surface, and there's still so much more that we need to do. By signing up and attending these webinars, we know that you are already invested in this work with us, that you're curious and committed educators who want to make a difference. We welcome you as partners in this work, and we ask you to continue to build your awareness and skills to end the invisibility of Native Americans and to build a more accurate, inclusive, and just understanding of history. And now it's my pleasure to introduce the first of our speakers for today, Dr. David Wilkins. Dr. Wilkins is a citizen of the Lumbee Nation of North Carolina, and he currently serves as the E. Claiborne Robbins Distinguished Professor in Leadership Studies at the University of Richmond. Wilkins concentrates much of his work on Native politics and governance, with particular attention on the transformations that indigenous governments have both coercively and voluntarily engaged in from pre-colonial times to the present. The concepts of Native sovereignty, self-determination, and diplomacy are at the heart of Wilkins' research and teaching. He's the author or editor of a number of books, including documents of Native American political development and Hollow Justice, Indigenous Claims Against the United States. So now, please welcome Dr. David Wilkins.
Thank you. We have very little time to cover two very important elements in the Native European Euro-American relationship, the colonial and treaty eras. And while the colonial era had a beginning and ending point, I will argue that treaty making has continued across time, though under different guises. Indigenous peoples, numbering somewhere between 7 to 12 million, inhabited North America since time immemorial, and these diverse societies wielded a great variety of social, political, linguistic, and cultural systems that generally worked well in the geopolitical landscape they called home. Thus, by the time Europeans first began to arrive, Native peoples had a long history of interaction with one another, consensual and conflictual, and knew full well how to engage in diplomacy with other peoples. European arrival / discovery in our world in 1492 shook the foundation of the Old World and initiated a movement to establish a body of international law as it cast a light on the tense relationship between the Pope and the Catholic Church and the divine right of kings, and because there had been no reason to believe the world was any larger than Europe. But Columbus's voyages considerably expanded these limited horizons and made it necessary for Europeans to find a way to understand a much larger world peopled with indigenous nations. Questions like, who were the natives in the Americas? And what relationship did they have with Europeans, who at the time of discovery shared, if nothing else, a universal belief in the Christian interpretation of the world and of human history? The Catholic Church was quick to respond to this intellectual and spiritual dilemma. And in 1493, the Pope issued the famous bull Inter Caetera, in which the Church granted to the kings of Castile and Leon all the lands and countries the Spanish had discovered or might discover in the future. But our lands were not the Pope's to grant. But in the European mind of the time, the Pope was understood as holding virtually total power, and his word was considered supreme. Not long after, Spanish theologians composed a legal document, the Requirimiento, or requirement, in 1513, which was to be read to the indigenous peoples of the New World when they were contacted by Spanish explorers. The document recited the history of the world as Europeans then understood it and called upon the native peoples to submit themselves to the authority of the Spanish monarchs and the Pope or face the justifiable wrath of the Spanish military. The Requirimiento was the moral justification used by the Spanish to dominate, kill, Christianize, and control indigenous peoples, and it provided the intellectual context within which international law began to develop. Felix Cohen, considered the father of federal Indian law, writing in the 20th century, wrote an article in 1942 in which he argued that Spanish laws and policies, in fact, formed the foundation of U.S. federal Indian law. Additional debates were held by the Spaniards regarding whether native peoples were free persons or slaves, and there were a number of papal bulls that sought to refine and clarify the rights of Europeans in newly quote-unquote discovered lands, and what responsibilities, if any, the Spanish had to assist natives. Thus, two additional doctrines also emerged during this period, the trust doctrine and the doctrine of discovery. These two doctrines still form the foundation, along with treaties and plenary power, of federal Indian policy and law, and continue to influence our rights as nations. The trust doctrine, as laid out by the Pope, meant that the Spaniards had a moral obligation to save the Indians from themselves, since they were not Christian and needed to be converted. Of course, in treaty making, trust is also a fundamental feature and means that both parties to a treaty should be able to trust the other party to fulfill their end of the treaty's provisions. Today, it entails the legal and moral duty of the federal government to assist Native nations in the protection of their lands, resources, and cultural heritage. The discovery doctrine is a multifaceted concept that has at least three distinct meanings in the law. First, it sometimes means absolute ownership of lands that the discoverers arrived at, claiming that they were the actual owners and Native peoples were left with no land rights whatsoever. But it also has a second definition, expansive ownership. And by this definition, the United States gains superior title, but natives are reserved a lesser or occupancy title, sometimes called an Indian title. And third, it also sometimes means preemption. That is, the first European state to plant its flag secured the preemptive right above all other competitors to approach the indigenous peoples in the area and ask them to sell them some of their land. This concept of the doctrine of preemption limits European powers, and it did not, in fact, affect the inherent rights of ownership that Native peoples held. Bartolomé de las Casas and Francisco de Vitoria, recognized today as two of the founders of international law, drafted documents in the 16th century. Vitoria wrote his in 1532, which acknowledged that indigenous peoples owned their own lands, not the Pope or explorers. The doctrine of discovery, colonial powers gained only a claim against other contending colonial powers, and not against indigenous nations. In addition, they acknowledged that only tribal consent or military conquest in a just war could extinguish the Indians' title to their lands. This understanding of discovery remained in place until John Marshall redefined it in 1832 in his critical case, Johnson versus McIntosh, which elevated federal land title over indigenous land title. Spain, England, France, the Netherlands, Sweden, Russia, and Portugal all established colonies in the Western Hemisphere, and each of these powers negotiated treaties with indigenous peoples. Some 450 were negotiated between 1607 and 1774. Colonial treaties were more about military alliances, friendship, trade, and commerce, and they were somewhat less about land cession. Colonies became important pieces of real estate in the wars that ravaged Europe for the next 3 centuries. And while each state had its own way of dealing with indigenous peoples, they all generally accepted and respected the doctrines described earlier, most notably the doctrines of discovery and treaty making. Over time, the 3 dominant players became Spain, England, and France. But after the 7 Years' War, 1756 to 1763, Great Britain stood alone on the eastern seaboard, and France argued a presence in North America only by having ceded sovereignty of most of Louisiana to Spain just prior to making peace with England. Spain had settled portions of Florida, Georgia, and the Carolina coast, but lacked the will and the resources to defeat the Creek and Choctaw nations, so it sought to maintain favorable trading relationships with the southeastern Indian nations. Spain, of course, had no European competition in the Southwest or on the California coast in its claim to those lands. Since the English had been dependent on the native peoples, particularly the Haudenosaunee Confederacy, the Iroquois nations, in defeating the French, they wisely recognized the national status of the major native nations of the interior and generally forbade colonies from dealing with the native nations on any consistent or substantial basis. In 1763, the King of England established the Royal Proclamation Line, a boundary line running along the Allegheny Mountains beyond which English colonists were forbidden to go. It was ineffectual, however, in stopping Western migration, but sent a message that the Crown still sought to maintain control of its people and the colonists. The king also organized departments of Indian affairs that were responsible to the Crown, not the colonial governments. English treatment of native peoples was similar to how the Pope originally operated, in that private contributions toward the conversion and civilization of native peoples were encouraged, but commerce and trade rather than Christianity dominated English colonial concerns. The leaders of the American Revolution and the authors of the U.S. Constitution had a definite English heritage insofar as they understood the nature of their native relationships. First, there was no question that they believed that they owned the clear legal title to the lands of the continent they had wrested from Great Britain, although native nations were recognized as having a lesser title of occupancy. And second, they recognized the wisdom of the English policy of negotiating treaties with native nations and recognizing their national character, their political sovereignty, and their power to wage war. And third, there was no question that the Americans believed that native peoples were culturally and intellectually inferior to whites and needed to be transformed into civilized human beings by becoming Christian, receiving a Western education, and through the imposition of the rule of law. This is borne out in the clause of the 1776 Declaration of Independence, recently celebrated, which declares that, quote, "He, that is King George III, has excited domestic insurrections amongst us and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions." Contrast this statement with language in the first formal treaty between the United States and the Delaware Nation 2 years later, in 1778, which emphasized a very different take on indigenous character. An invitation, in fact, to join the American Confederation of States as a sovereign state with congressional representation. Article 6 of that treaty declares that, quote, "And it is further agreed on between the contracting parties, should it for the future be found conducive for the mutual interest of both parties to invite any other tribes who have been friends to the interests of the United States to join the present Confederation and to form a state, whereof the Delaware Nation shall be the head and have a representation in Congress." This provision to create an indigenous state never materialized, of course, but it reappears a number of times in subsequent debates, up to 1906, when the 5 civilized tribes of what is today Oklahoma crafted a constitution for what they were going to call the state of Sequoia. There was a fair amount of talk about this that year, but ultimately white policymakers in the Indian Territory and at the national level pushed the Indian state idea aside to make room for what became Oklahoma. The heritage of the European Euro-American claim of legal title to native lands has remained constant from 1492 to the present day. The language used has changed, of course, when talking about native land rights, and we now hear U.S. policymakers describe Indian lands as being held in trust by the United States. But this is a euphemism that simply avoids the necessity of remembering that natives, with rare exceptions, are not thought to actually own the complete legal title to their own homelands and may still be dispossessed by the federal government at any time. Now let me move to discuss treaties in the remaining 15 minutes. Paul Peyton recently had this to say about treaty making. Quote, "There is a fundamental ambivalence in treaty making. On the one hand, it is widely recognized that European law in general and the practice of making treaties in particular were instruments of empire, offering an alternative to the use of force in the acquisition of new territories and the dispossession of native inhabitants. On the other hand, the idea and the ideal of a treaty relationship are often held up as a means to the resolution of conflicts between governments and indigenous peoples, and a potential source of legitimacy for states established by colonization and a recognition of inherent sovereignty of native nations." Keep that inherent ambivalence in mind as we move through this discussion. Indigenous diplomacy and the accords, the treaties that ensued affirm indigenous sovereignty and our national and international status. While most of our nations agreed not to negotiate treaties with foreign powers once we'd signed treaties with the United States, nothing prevents us from negotiating treaties with one another. Of course, long before Europeans arrived, we engaged in diplomacy with one another to establish peace, conclude conflict, and to make relatives. Indigenous diplomatic affairs tended to be spiritual events that forged new kinship relationships. I would define our historic treaty making as, quote, a sacred process whereby two or more peoples become relatives while retaining their own inherent political and cultural identity. Treaties acknowledge our extra-constitutional status. That is to say, our nations and our governments were not created by, nor are they subject to the United States or state constitutions. We are, of course, connected to the U.S. by our treaties, but we are not constitutional creatures. The United States Constitution does not directly limit our governing powers, although the congressional plenary power concept that the Supreme Court invented in the late 19th century has been utilized time and again to destroy or minimize any right that we possess. Our extra-constitutional status marks us as unique political bodies. We were here before the state or federal constitutions were created, and since our rights are not based in U.S. constitutional law, they are generally not protected by U.S. constitutional law either. As Clarence Thomas of the U.S. Supreme Court put it in an important case, United States versus Lahr in 2004, quote, the states, unlike the tribes, are part of a constitutional framework that allocates sovereignty between the state and the federal governments. The tribes, by contrast, are not part of this constitutional order, and their sovereignty is not guaranteed by it. This is a chilling reality that we must always be aware of as indigenous nations. More recently, in 2014, the Supreme Court in Michigan versus Bay Mills said that, quote, as dependents, tribes are subject to plenary control by Congress, end of quote. But the court also said, and yet we remain separate sovereigns, pre-existing the Constitution. Tribes, Justice Elena Kagan said, exercise sovereignty subject to the will of the federal government. This leaves us in a most tenuous political position. But if we're not constitutionally created, how can the U.S. Congress claim to wield virtually absolute power over us? And yet it does just that. Vine Deloria, the leading figure, the authority on indigenous treaty making and diplomacy, defined treaties this way. He said that while they had legal and political importance, treaties were primarily documents of diplomacy, in which two or more nations pledged their honor to regulate their future relations according to a set of mutually agreed upon principles. The most important requirement in fulfilling the provisions of a treaty is that of goodwill. Legal points are not nearly as important as the desire and ability of each nation to undertake positive and affirmative steps to ensure that their pledges of good faith were not carelessly broken. The arrival of Europeans, of course, led to a transformation in what had once been a spiritual relationship to a more contractual relationship. Although the first 200 years of indigenous European Euro-American diplomacy generally followed native protocols, took place on native lands, and employed native language and symbols. A standard definition of treaty making from a Western perspective is that it is, quote, an agreement normally written, concluded between two or more states or other subjects of international law, intended to create rights and obligations between them that will be governed by law. Although this definition sounds compelling, Charles de Gaulle, France's president in the 1950s and 60s offered a more realistic account of the import of treaties. He said, quote, "Treaties, you see, are like roses. They last while they last." In other words, even when they have the backing of national and international law, they can be broken or abridged whenever it suits one or both of the parties' interest. Although in our case, we rarely violated treaties, and the United States frequently did. And this is where we had and still have all sorts of issues with non-native treaty negotiators and their descendants, since we were operating and interpreting our treaty relationships on a spiritual plane, and they were generally operating strictly on a politically or economically expedient plane. This issue continues to plague indigenous federal relations to this day. That said, we are the only racial ethnic peoples in the U.S. that participated in treaties with the United States. Hawaiian natives were also very active in treaty making with numerous European powers. Hundreds were negotiated by various foreign powers, and native nations from the early 1600s to the late 1700s and even later. The United States alone negotiated over 600 from 1775 to 1871, when the process in one form was stopped and then transformed, though the United States claims to be legally bound by only 377. These treaties today form the bedrock foundation of our sovereign rights. They provide our peoples with a set of property, identity, and cultural rights that are unavailable to other ethnic groups. After all, only nations can negotiate treaties. Our nations then have a status higher than that of states, since we've done what they have never been allowed to do: forge treaties. Many treaties, especially after the War of 1812, were land cession agreements in which the United States pledged to our nations, in exchange for the lands we were ceding, that it would provide any number of services, protections, exemptions, and would respect all the sovereign rights we had not given up, but retained to ourselves. The Mille Lacs fishing rights case in 1999 is one such instance. That important Supreme Court decision reaffirmed the 1837 treaty. It did not give the Anishinaabe rights to hunt, fish, and gather wild rice on ceded lands. It recognized that they had always had those. In addition to the ratified and unratified treaties, there were another 50 or so agreements which were concluded between 1872 to 1914. Vine Deloria and Felix Cohen always insisted that the only difference between agreements and treaties was that the House also had to ratify the accord and not just the Senate. Hence, our fundamental relationship to the United States is a political one of a sovereign to sovereign or government to government, not a racially based relationship, and not that of an individual to the government. The treaties and agreements and their ongoing validity, though unfortunately not their consistent enforceability, recognize this. Treaties were made for different reasons, depending on the time, the parties, and the events. Typically, the subject matter of treaties might entail peace and friendship, military alliance, boundary establishment or modification, and trade or some combination. And the scope of treaties was also quite broad, ranging from the international recognition of the status of native nations, war and peace provisions, boundaries, passports, extradition, relations with third powers, alliance with the United States, accepting federal protection that was offered to them, agreeing to exclusive trade relations, commercial relations, land cession, reserved rights in ceded lands, payments and services pledged to tribal nations, and of course, jurisdictional matters, both civil and criminal. Vine Deloria, who wrote the definitive work on Native diplomacy, pointed out that there were three basic kinds of rights contained in every treaty: corporate or national rights, individual rights, and property rights. Corporate or national rights are those who consist in preserving the political identity of the community, its right to self-government, and to continued recognition and negotiations. Some rights to hold property, usually real property, are also corporate rights. For instance, the right to hold property in common, which is a standard feature of many treaties. Individual rights. These usually consist of eligibility for allotments, receiving special reservations of land or specific sums of money or goods. Surprisingly, promises of educational, health, and other services are not generally regarded as individual rights, but as benefits that are due the nation itself. And third, property rights. These link closely with corporate rights, but are also distinctive. The right to hunt, fish, gather maple syrup, wild rice are found in treaties, and these are certainly property rights. But in order for the individuals to access these rights, it's necessary for the tribal government to take action to properly allocate the use of a given resource. What is the status of our treaties today? The U.S. Constitution declares them to be the supreme law of the land. Why? Because they embody the character of a nation. So in theory, you would think that they have an elevated status over regular laws. Over the years, the courts have also created several principles of law that have occasionally benefited our peoples. One of the most important doctrines is the reserved rights doctrine, which holds that treaties weren't grants of rights to tribal nations, but a taking away or diminishment of rights and a reservation of all the rights not specifically ceded. This doctrine is comparable to the U.S. Constitution's 10th Amendment, which declares that the powers not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states or the people. The problem for us is that the 10th Amendment is embedded in the Constitution, and the Indian Reserve Rights Doctrine is merely a legal doctrine, which can be ignored by the Supreme Court whenever it suits their political agenda. And the courts have also developed the so-called canons of treaty construction, which hold that any ambiguities in treaties or doubtful clauses should be interpreted the way we or our ancestors would have understood them. In other words, we're supposed to have the benefit of the doubt when there are conflicting interpretations of treaty clauses. Of course, the court ignores both these doctrines as often as it adheres to them, so they have proven inconsistent in protecting our inherent treaty rights. More importantly, because of the trust doctrine and the plenary power doctrine, and because we have a political relationship with the U.S., the courts and the political branches have placed themselves in a superior position to us and our treaties, and they can disavow or ignore these whenever it is convenient for the federal or state governments. And there is another important principle that works against our treaty rights. Even though the courts have sometimes held that treaties have an elevated status compared to congressional statutes, the justices have also frequently said that treaties have the same status as congressional laws, and they follow the principle that they will not go beyond the written evidence to inquire into the validity of treaties, since treaties are viewed as political arrangements, best left to the political branches for construction, interpretation, and enforcement. So in those instances when tribal nations have tried to argue that fraud was involved in certain treaty negotiations, the courts have more often than not said it was not their job to question whether or not fraud had occurred. This was established in the Lowndes decision in 1903. But if it's not the Supreme Court's job to do that, then whose job is it? Another doctrine that is particularly disturbing in the case of our treaties is the so-called last in time, first in right rule. This was established in a case called the Cherokee Tobacco case in 1871, when the court held that a later statute could override a previous treaty. And since treaty making was largely curtailed in 1871, and Congress has continued to make laws since then, well, you get my meaning. Finally, when there is a conflict between how we interpret a treaty provision and how the federal government or the states interpret the same, where does that argument get resolved? in tribal courts, in an international court? No, it goes through the federal courts. So there is a built-in disadvantage that makes it hard for us to secure a fair adjudication of our most important foundational rights. Despite all the problems associated with our treaty history, they still provide us with a politically recognized sovereign status that is distinctive and powerful, and that sometimes leads to impressive victories, like the McGirt decision from last summer, which affirms the ongoing reservation status of the Muskogee Creek people, a huge victory for the Creek nations, and by implication, other nations as well. But the burden, it appears, will always fall upon us to remain ever vigilant about these rights, or they can be diminished or completely disavowed because they remain fundamentally political and completely subject to interpretation by the federal courts. Thank you very much.
Thank you so much, David, for that insightful overview of what is a very complex history. Next, Dr. Wilkins is going to be joined by Dr. Mark Hirsch for a conversation about the colonial and treaty eras. Dr. Hirsch is a historian at the National Museum of the American Indian. He has done research for numerous NMAI exhibitions, including most recently Native New York, which opens at the NMAI in New York in 2021, and Nation to Nation, treaties between the United States and Indian nations. He's the co-author of Why We Serve, Native Americans in the United States Armed Forces, and the author of Race and Sovereignty in the Cherokee Nation, an essay that was published in Indivisible, African American Native Lives in the Americas. Mark received his PhD in American History from Harvard University in 1984. Please welcome Dr. Mark Hirsch.
David, thank you so much for that really compelling discussion. I'm rather amazed that you were able to condense that much history into 30 minutes. It was really a remarkable achievement, and I salute you for that. So for the next 30 minutes, David, we are going to talk some about the presentation that you gave, and I wanted to sort of drill down into some of the topics you raised, but mainly from the perspective of how teachers might be thinking about this, and how teachers might be able to use some of this information in discussions with students in their classes. So with that aim in mind, I guess I'll start off sort of jumping in the deep end with you. And that is, why do treaties matter? And how, you mentioned this, how do treaties make Native people in the United States unique in some ways, in many ways, from other American citizens?
Thank you, Mark. I appreciate that. Treaties are fundamental in that they recognize, as I said earlier, our inherent sovereignty. We were here before anybody else arrived here. We existed as nations where there were well over 600 indigenous nations. And as the European powers began to arrive, they needed to find a way to engage us. And it very quickly became clear to them that the most reasonable way, the most sensible way, the most economically expedient way to do that would be to establish diplomatic relations with us. And those treaties and accords and agreements, they were known by many names, affirm our inherent sovereignty, our national status. They provide, as I said, property, identity, and cultural rights. They also provide the United States with its lands and its legitimacy as a state. And that's one of the key distinctions that isn't often made, in that treaties belong to both indigenous peoples and to the American people, because they created a codependent relationship between our respective nations. And they also establish a trust relationship between indigenous peoples and the federal government. And incredibly important, they established that the doctrine of consent should be the basis of our relationship with the federal government. And that's a doctrine that has been assaulted over time in various ways because of treaty abrogations, but it remains at the core of the relationship between Native peoples and the federal government. And while race has always been a factor, the treaties establish that we have a fundamentally political relationship with the federal government, and that we are, in fact, nations, which no other racial or ethnic group in this country can assert.
So that really, in a way, would answer a student's question about, what is it that, or well, not so much a question, but a student saying, well, aren't Native Americans just another minority group or an ethnic group, correct?
Right. Absolutely. In fact, in a textbook that I wrote, a chapter begins that indigenous peoples are nations, not minorities. Demographically, of course, we have a minority status because there are so few of us, less than 6 million, but it is the political dimension of our existence and the fact of treaty making that affirms our nationhood and the fact that we are governing bodies, and we predate the federal and state governments. And the treaty making confirms that governing capability that we possess that no other ethnic group has in the country.
Right. So, David, I wanted to talk some about the colonial treaties that you referenced, and beginning with the what you call the doctrine of discovery, by which it appears that European powers, England, France, Holland, and others, basically laid claim to the Americas or justified for them the colonization of the Americans. Is it fair to say that the doctrine was mainly a way of warning off other European powers from saying, from colonizing parts of the Americas that had already been discovered by a European power? Or was it mainly a way of telling indigenous people, essentially, that their lands were no longer theirs?
Yeah, that's an excellent question. And the shorter answer, Mark, is that it was both. As I mentioned earlier, the doctrine of discovery has over time acquired different meanings, different iterations, depending on who is doing the articulation of the concept. It's been a very malleable and therefore very useful political and legal doctrine, depending on who is wielding it. As I said, the Pope originally imagined that because we were non-Christian, that we could not own title to our own territory. But that's where Las Casas and Victoria said, no, that's not true. They are, in fact, the true owners of their own land. But when John Marshall and the U.S. Supreme Court has established, Marshall in 1823 and Johnson versus McIntosh completely transformed the doctrine and elevated federal status and federal land title above that of native land title. He didn't completely erase indigenous land title, but he said that ours was inferior to that of the federal government. And then later, various other Supreme Court cases, most notably a decision in 1955 written by Justice Stanley Reed, Teton versus United States, declared that Alaska Natives, because of the doctrine of discovery and the related doctrine of conquest, had no land rights whatsoever. So that's doctrine of discovery as absolute title. And that doctrine has never been disavowed by any subsequent Supreme Court. And so you have those three very different definitions. But the one that you mentioned earlier, that is, it was a device concocted by European powers, ideally to help prevent bloodshed and warfare between the various competing European powers. So it really was a doctrine of preemption. And when you read the actual treaties, I've read virtually all the treaties that were negotiated between the United States and tribes, and there's no reference anywhere to the doctrine of discovery. What the U.S. government is usually saying is, we see that you own the land, we would like to buy some of it from you. So, so you go back to the Louisiana Purchase. The United States didn't buy the land from France. They bought sovereignty. They bought governance over the land, not the actual land, because they then subsequently negotiated dozens, if not 100 or more treaties with the native inhabitants of those lands. So the doctrine of discovery has these three very different meanings, which continues to cause profound problems for Native peoples, because we never know which definition a congressperson or Supreme Court justice is going to use. We just know what we understand from the treaties that were negotiated, and that is that they just gained the right to be the first purchaser. They didn't gain our land outright. They gained the right to be the first purchaser of land in competition with other bodies who wanted our land. So that's a very different meaning than absolute title.
Right, right. It's almost like the right of first refusal or something like that, right?
Precisely, yeah.
Yeah, right. So I wanted to ask you another question, David, about colonial treaties. We know that the colonists who came to the Americas and the native peoples they encountered here obviously spoke different languages and had different traditions. And when I think about those colonial treaties, I often wonder, did native people understand what they were consenting to in these treaties with Europeans? So you mentioned, for example, that native people, even before Europeans came there, had their own protocols of diplomacy. They had their own sort of agreements with other tribal groups, and they were not written, but they clearly were agreements before Europeans came. And now Europeans come, and for them, everything has to be written down. Everything is a legal agreement in some ways. And I guess my main question is, native people had what you called a kind of a spiritual understanding of those agreements before Europeans came. That when they negotiated with one another, there was a sort of a spiritual understanding of what these agreements were about. Did native people understand what was going on, in your opinion, in the kind of the early colonial treaties? Did they understand what they were signing, or were they basically snookered into something by the European colonists?
That's another excellent question, Mark. And the short answer is yes and no. Native peoples were very savvy, very astute, having engaged in diplomatic affairs with other native peoples throughout history, throughout the millennia. Europeans arrived, as you noted, and as I pointed out earlier, with a very different mindset, a mindset driven by politics, driven by economics, driven by trade. And so indigenous peoples sometimes were very adept at negotiating once they understood who they were negotiating with. So that when you look at the early treaty when you look particularly at the early treaties from 1607 to the 1770s, indigenous peoples were frequently very keen and very aware of what was happening, and they learned very quickly that the English colonists were intent on securing lands. And indigenous peoples early on believed that they were sharing land with the Europeans rather than giving them outright title to those lands. Right. So it's a question that varies widely depending on the era in which the treaty is negotiated, depending on the tribal nation that's doing the negotiation, depending on how a tribe had been impacted, say, by depopulation from diseases. There are lots of factors that come into play. And really, you can put many of the treaties on a spectrum from coercion to consent. And depending on the tribe and depending on the issue and depending on the time and the era, some tribes fared better than others, depending on their own military capacity, depending on their leadership. I mean, some of the 5 civilized tribes had attorneys representing them in the early 1830s, 1840s. Most tribes in the West did not know what an attorney was until much later in the game. So it's a question that you almost have to look at region by region, tribe by tribe, because it was so complicated and such a mixture of ideologies and actors involved in the process.
Right. It sounds like Native tribes, as time went on, the Native leaders got pretty hip to what was
Right.
going on, and they kind of acquired a pretty deep understanding of the European notion, say, of private property.
Right, precisely.
Yeah.
There's a great book written by Martin Case called The Relentless Business of Treaties.
Right.
He did a study of the several hundred white treaty negotiators representing U.S. interests and what motivated them. He doesn't examine indigenous treaty makers and who signed for us. That's a book that still needs to be done. But he points out that, greed, corruption, alcohol, there are many things, weapons used by white policymakers as they sought to secure more and more of our lands. And Native peoples once they caught on to how the process was played out, they became much more astute, much more resistant to what was happening. But over time, of course, as their power waned and federal power waxed, even when we knew what was happening, we could no longer stop it from happening. And that's when you have many of the late treaties in the 1850s, 1860s that really represent and elevate the federal government to a much more powerful position.
Right. So it's really important for students to know that treaties are not made as sort of on equal ground.
Right.
That the ground is shifting as the United States becomes more populous, more powerful. Native nations, I guess, are losing population for a variety of reasons and becoming somewhat less formidable, say, than they had been in the 17th and the 18th centuries. And as that happens, the bargaining power in some ways declines. Right. Is that fair to say?
That's a very accurate statement. Yes. Mm-hmm.
Let's move on to treaties between the United States and Native tribes. I could talk to you about the colonial treaties probably for another 2 or 3 hours because I really find them really fascinating. But I guess we should move on. So you said that the United States negotiated about 370 odd treaties with the United States, and I guess this is another $1 million question. Were all of those treaties broken?
Vine Delory was asked that when he was giving testimony in the 1990s by Senator Daniel Inouye, and Vine Delory said, provisions of every U.S. Native treaty have been violated, but only a handful of complete treaties have been formally abrogated by the U.S. Congress. And fortunately, that's one of the strengths of treaties, is that a provision can be abrogated by a statute or by a Supreme Court decision or by some agency, but the rest of the treaty remains intact. That's what has saved indigenous peoples. That's what saved our remaining lands. And that's very important. As I've been doing research on treaties over the years, one of the handful that was formally abrogated involved the Dakota people of Minnesota in 1862. They had faced starvation by the Indian agents, and they put on the paint and just went on a rampage because they were tired of being starved to death. The federal government responded by, corralling them all. It evicted most of the Dakota to the west and hung 38 individual Dakota. And then Congress passed a statute that formally abrogated the Dakota treaties in 1862. That's one of the rare times that Congress has taken that step. And the Supreme Court made clear just last summer in the decision that Neil Gorsuch wrote for the court in the McGirt decision, McGirt versus Roberts, that reaffirmed that the Creek Reservation was still intact and had been since the 1830s, that the only way a treaty can be abrogated is by a formal act of Congress. So while, as I said, provisions of every treaty have been abrogated, only a few formal treaties in total have been abrogated. And that's why they remain so vibrant for Native peoples, because indigenous peoples have found ways through their own political development and cultural evolution to utilize those provisions that haven't been abrogated to revive and resuscitate their own their own national character and nation building.
Interesting. Another question, I guess, that comes from the perspective of a student. What if a student were to ask a teacher, didn't treaties give land to Native people, to tribal nations rather, in the form of reservations? And secondly, weren't some treaties, really good for Native people?
Mm-hmm. Well, the federal government rarely gave any land to tribes. And if it was giving any land, it was giving land that belonged to other tribes, you see. Most treaties, in fact, particularly those post the War of 1812, were land cession treaties in which indigenous peoples both voluntarily and involuntarily surrendered title to much of the land that became the United States of America. And sometimes, of course, the United States exchanged in treaty making, exchanged lands with tribes, like with the 5 civilized tribes when they were trying to get the Indian Removal Act passed by Congress. They wanted the Indians in the East removed to the West. The tribes in the East negotiated treaties in which they exchanged lands they were then living on for new lands that they were going to acquire in the Indian Territory. So you had those kind of exchanges that took place. But it's rare that the United States ever gave anything to tribes. They were usually trying to extract something from tribes, and it was typically the land.
Right. So a related question, actually. I mean, again, if a student were to ask a teacher, don't treaties give sovereignty to tribal nations? There was an American president not too long ago who actually said that in answer to a question from a reporter. And I wonder how you would get at that issue, that somehow tribes are given rights via treaties.
That's one of the most difficult misnomers that we've been trying to, straighten out for a long time, because there is this sense that the United States gave lands, gave reservations to tribes. But the important point to remember, and it was best expressed by a U.S. Supreme Court case in 1905, United States versus Winans, where the Supreme Court said treaties were not a grant of rights to the Indians, but a grant of rights from them. In other words, we had what the United States desired, which typically was land or right of way or timber or something. And so they encouraged us to negotiate with them so they could gain access to that. So for those tribes that did not sign treaties, in theory, they still retain the bounty of their inherent rights, right? And yet that hasn't worked out so well. And then, of course, you have other tribes like the California nations who signed 18 treaties in 1851 and 1852, in which they surrendered 90% of what is now California to the federal government in exchange for recognition of their sovereignty, recognition of other rights and resources. But those treaties were subsequently hidden away in the U.S. Senate, and yet the tribes had lost all of their land, and they had to file claim cases in the 1920s to try and find some way to recover some of their rights, but the damage had been done. And then you have other tribes that never signed treaties, like the Hopi Nation in Arizona, and many other tribes that never signed treaties. It's because they had no lands that were desired by the federal government, of course, and they never posed a military threat to the United States like the Navajo Nation did early on. And yet, because of the pre-existing trust relationship, the United States has forged a political relationship with the Hopi and every other tribe that it has recognized. And so that's how the Hopi have an agent, just like the Navajos have an agent. Even the Navajos signed multiple treaties, even though the Hopis signed none. And yet they're still considered a federally recognized tribe because of the trust relationship that they have with the federal government.
Interesting. Here's a true or false question. Uh, treaty making ended in 1871. True or false?
That statement is false, I believe. There are many books and many law reviews that say that it's true that treaty making ended. The process was stopped momentarily by an Indian Appropriation Act writer at the behest of the House, who was having to produce all this money to, take care of the treaties that had been ratified by the Senate, and they felt frustrated because they were not having a say in the treaties that they were having to fund. And so, at their request, largely, they were able to strike a presidential power. And yet, they, but within a year, the Commission of Indian Affairs contacted Congress and said, "How are we now to deal with indigenous peoples since you stopped treaty making?" And so they revived the process and began making new treaties in 1872. They just termed them agreements. But as Felix Cohen, the father of federal Indian law, said in 1942 in his Handbook of Indian Law, the only difference between a treaty and an agreement is that an agreement is ratified by the House and the Senate, and whereas a treaty is ratified only by the Senate. And those agreements will continue to be made until 1914. And today we have, dozens of negotiated settlements that are being negotiated over water rights, child welfare, gaming, compacts, and so on. All those involve diplomacy. They all involve the federal government trying to secure indigenous consent. And so Vine Deloria, in his 2-volume study of treaties that he worked with Raymond Damali on, said, and the title of that book is American Indian Diplomacy from 1775 to 1975. So Vine argued that treaty making, or 1979, but treaty making continues on to this very day, just under different guises, different nomenclature, if you will.
Interesting. I wish that information were better disseminated, because I keep seeing it in textbooks all the time.
Right.
The treaty making ended in 1871. Full stop.
Exactly.
So, one or two last questions, because I see we only have about 4.5 minutes left, David. Treaties, as you said, are the sort of the bedrock of tribal sovereignty, of tribal rights in some ways. I think you may have put it. And clearly, treaties recognize nations as sovereign nations. And yet, in your talk, it's very clear that the United States, certainly, from the 1830s at the very least, onwards through 1871, has tried, in some cases succeeded, in eroding tribal sovereignty through all the means you suggested, through the courts, through the idea of plenary power, even through the military, through Supreme Court decisions like the one you referenced by Justice Marshall. How did Native people keep the idea and the reality of sovereignty going in the face of what strikes me as a sort of multi-pronged assault on tribal sovereignty?
Yeah, that's an excellent question. Indigenous peoples have a sense of that as the original peoples of the land. They have a spiritual bond to the land, and they know in their history of dealing with foreign powers and dealing with them and seeing how slippery that political and economic relationship has been, they still maintain an element of trust, an element of faith, an element of hope, if you will, that the rule of law matters. And so they've been very persistent, very resistant, and very willing to engage and continue to hold out hope and trust, if you will, that the United States, even when it's violating treaties, even when it's violating statutes that have affirmed certain rights in tribes, indigenous people still continue to believe that eventually they're going to do the right thing. And under the Trump administration, of course, his administration, was damning on a number of levels for indigenous peoples. Indigenous people simply hunkered down and held on and dealt with what they had to do. They continued to file lawsuits. They continued to engage with states. They continued to engage with those agencies of the federal government that they had to deal with. And now Biden is in the office and things have turned around yet again. So there's this constant vacillation, a constant ambivalence. And indigenous peoples, we become attuned to that. We find it very frustrating. We find it sometimes embittering. And yet, we believe strongly in our national character. And we still see a bright side to federal lawmakers, even when they don't always see it in themselves, in terms of how they act and how they deal with indigenous peoples. And so it's a constant struggle, and we have to remain vigilant in looking to protect and maintain what's left of our lands and our rights and our cultures and languages.
Right. David, I can't thank you enough for this presentation. Again, I think it would be very easy for us to continue this discussion. I think there are questions of the colonial period I would like to ask you, questions about the treaties that were negotiated in the 18th and the 19th centuries, and the agreements that were formed and forged afterwards. But alas, we're running out of time, but I do want to thank you. Perhaps someday we all can get together again and ask those unasked questions. And I think in the meantime, we are all really the beneficiaries of your wisdom and your thinking about this subject. And I just want to thank you so much.
Thank you very much, Mark. I really enjoyed this.
Dr. Wilkins and Dr. Hirsch, much respect and gratitude to you both for that wonderful conversation. It really helped to highlight some of the key issues from the colonial and treaty eras, and I especially appreciated how you were able to distill this very complex history down to some of the most basic but really important questions about treaties that we do often hear from students and the general public. So for this first session of our Institute, I think there are several key takeaways that I'd like to reinforce. First is that understanding colonial and U.S. policies give us a much broader, inclusive understanding of U.S. and world history. These policies are really essential to understanding the status of Native American nations in the United States today. Before there were colonies, Native nations existed as sovereign independent entities, and colonization led to the need to establish new international relations between Native American nations and countries such as England, France, Spain, and Holland. Native Americans brought very different concepts of lands, agreement making, and other cultural differences to their negotiations with European powers and later the United States. Native nations are holders of inherent rights, such as various national, individual, and property-related rights. As such, treaties with the United States did not give rights to tribes. They recognized the tribe's inherent rights, and they were negotiated documents of diplomacy to regulate and agree on a government-to-government relationship with Native nations. Native nations retained the inherent rights that they never ceded. And while some provisions of all U.S. Native nation treaties have been violated, only a handful of treaties were ever fully abrogated. Native nations still exercise self-government within the United States today. This status has been upheld by treaties, court decisions, executive orders, and acts of Congress. So this brings to a close our webinar for today's Institute. And I'd like to say a big thank you, Mado, to all of the NMAI staff who worked to make this Institute happen, to our partners at Nalu Creative for their production work. Finally, we extend our gratitude to all of you for joining us today and for doing the important work of improving teaching and learning about Native Americans. Please join us for our second webinar tomorrow, which will explore the human side of removal, allotment, and assimilation. And this will feature presentations by our distinguished guests, Candace Teehee from the Cherokee Nation and Julie Cajun from the Salish Tribe of Montana. Thank you. Have a great rest of the day.